A warm welcome to everybody. Well, I've been given a task today to help all of you, in a way, choose between civil and criminal law. And to begin with, I don't know whether my advice will be the best advice because, in the end, whatever choice you make, a criminal law or a civil law, Indian, we all are lawyers, and you're choosing a field to making an option between civil law or criminal law is not something which is a compulsion at the end of the day. It is just something which people end up choosing to do because of convenience, and that is my opinion. But having said that, yes, there are two fields of law which we'll be discussing today, one being the civil law and one being the criminal law. And that does not mean that you have to make a choice, and I'll come to that a little later. But having said that, let's begin with what is exactly civil law and criminal law. So when we speak about civil law and criminal law, people generally have either, if you're not from the law background, which I don't think anyone else over here is, everyone over here is from the legal background. So we generally tend to have a basic understanding of what is a civil dispute, what is a criminal dispute. But when we say criminal law, people generally have this colloquial way of saying ki criminal law matlab murder, bodily injuries, or something of that sort. Yeah, maybe there will be something like cheating or something in that aspect. But when you want to define what criminal law is, I don't think that by defining what an offense is or explaining or describing an offense, we understand what criminal law is. Because criminal law as a general concept is something which is much wider, and I can fairly say not very much known to general public. What is criminal law? So firstly, when we speak about criminal law, what we must understand is that criminal law at the end is something, it's an act done against the society. It's something which harms the society. It's a wrong to the society. And therefore, speaking generally, criminal law can be anything which can be said to be a vice and evil in society, which the law tries to remove by making it punishable, by making an offense. So that is what criminal law is. And then when one understands this is what criminal law is, this does not make it very clear that what acts will actually be criminal law, because then the query which will come forward from everyone is, what is civil law then? If this is criminal law, then what is civil law? Because civil law also involves some sort of you can say vice in society. Civil law also involves people's rights getting affected in society. So to understand what civil and criminal law is, I think the best way to understand these two concepts is that whatever is not criminal law, you can consider as civil law, except maybe constitutional law, which is a completely different concept in its own. And maybe we can have another lecture on to understand what constitutional law is. But when it comes to the understanding of the difference between civil law and criminal law, what we must bear is civil law is more general in nature. It is a wider scope, and actually to define something what is civil and what is not becomes very difficult, because 99% things under the sun are civil if they're not criminal. That's what I said. Maybe that 1% comes into constitutional law, but many times you can even consider constitutional law as civil law. Because finally, what we understand, and that is why I explained about criminal laws in the beginning, is that criminal law is a wrong against society, when civil law is a wrong, you can say, against a private individual. So to understand the difference between those two concepts, what one must bear in mind is that when you can say a crime is committed, under law, when a crime is committed, that means a wrong or an injury is caused not only to an individual victim, but to the society as a whole. And therefore, when we go into criminal law, as we know that generally it is a state who prosecutes a criminal offense in respect of criminal offense. But when it comes to civil dispute, that becomes a purely private dispute. That does not mean that you cannot file a civil suit against the state government, but that nature of the relief which you're claiming is of a private nature. It is a right which you're claiming, which is only injured, which causes injury to you. Many times these two rights, that is a civil right and a criminal right, or a civil wrong and a criminal wrong, they coincide. They aren't such separate entities. And today, with the development of law that it is, there's a very thin line between civil law and criminal law. Therefore, that is why I began with my talk today, that helping you all make a choice, or me suggesting a choice for you all, won't be the most apt way of going about these things, because to be honest, we all are lawyers at the end of the day, and we need to deal with all sort of cases. So just to understand the difference of these two, you might be able to take something back from today. But will this help you make a choice, or will this make it clear which choice you should make? I don't think so, because at the end of the day, the choice was already made when you chose to be a lawyer. So whenever you get any civil case or a criminal case, you're supposed to deal with it. Coming back to the difference between the two, like I said, criminal law is when there's a wrong caused to the society as a whole, whereas civil is when there is a wrong between two individuals. So when you understand what civil law is, as in general, which is the more general law, then you can differentiate and understand what criminal law is. And therefore, today, when you want to know what civil law is, you must firstly understand that civil law cannot be really defined. It is a ever-spreading concept. It's a legal concept which cannot really be defined, and therefore it's a very general law, and it includes everything possible. When you take the Code of Civil Procedure, it's an act enacted in the 1908. It means pre-independence. Another, you can say, dengi from the pre-independence government, that is the British colonial government. And this gift given to us has lasted for over 100 and so many years, but over 100 years this law has lasted. And this law basically defines the entire procedure for civil law. This law is so expansive that there are over 150 sections, and thereafter there are almost 50 orders. And the sections give the substantive parts, and the orders give the procedural aspects of the civil law. This code defines everything under the sun for the civil disputes. So when we come to a civil dispute, what one must learn and what one must know is the CPC. Unfortunately, we have, I think, in the legal law degree course, especially the course which I did from the Mumbai University, we have CPC as a subject only in your final year, and that also for one semester. It's impossible to study this wide code in one semester. In fact, I feel there needs to be an entire year just for CPC. It's such a complicated statute. And why is it so complicated? Why is it so vast? Is because it determines civil rights. And what civil rights are every right under the sun is a civil right. Any private wrong caused to a person is a civil right. In fact, when you look at section 9 of CPC, section 9 is so wide. It determines the jurisdiction of a civil court. And what it says is that unless prohibited under any special law, every civil dispute can be tried by a civil court. Civil dispute has not been defined in any other law. And therefore, civil dispute is what we can understand is a private wrong. So what can be a civil wrong can be anything, meaning even a criminal act has civil consequences. Similarly, any civil wrong has criminal consequences. But I'll tell you one thing 100%. There might be certain acts which will be considered a civil wrong, but they might not consider a criminal offense. But every criminal offense can consider a civil wrong. That is something which you must understand. So civil is something which is very general and very wide. So to understand civil law, maybe even in this 1 hour, half an hour discussion which we are having today, won't be possible. Or even that one semester studying CPC won't make you understand the procedure, how to deal with civil law. It is an ever-growing concept, an ever-learning stream. So for especially the budding lawyers today, like me, you must understand that civil law is not something which you will learn over the period. So if you think that today, if I hear this lecture and I will read CPC in the next 1 month, I will decide I want to become a civil lawyer. That is not going to be the case. You are a civil lawyer the day you graduated, and you'll continue being a civil lawyer, because the civil law is so wide, it will always include any sort of civil wrong. I'm speaking very general academically, but to give you an example, when you take a concept of trespass, when you trespass into someone's property, it is considered generally as a criminal offense, and there's a punishment under IPC. Or even let's take a case of when you cheat somebody. When you cheat somebody, cheating is a criminal concept which is included in the IPC, where when someone is cheated or when someone's property is trespassed upon, that is considered as a criminal offense, an offense against society. But that does not take the civil nature of this act away. Do you understand? The civil nature of an act does not go out of a criminal offense, and it will always be there. So if someone does a criminal offense, you can always claim civil damages, civil reliefs under the civil procedure against such a person. And that is how wide our civil law is in India. And especially in India, our law is based on common law. Now, most of you have studied jurisprudence, and when you understand what common law is basically codified law, law which depends upon precedents, and it is another inheritance which we get from the old colonial rule of law, which has been incorporated in our Indian system. So our law is based upon common law, law which is codified, and the codified civil law in our country. Till date, there is no way of there's no law which defines what can be a civil dispute. So therefore, what you must understand today is anything under the sun is a civil dispute. If a person is individually injured, if some wrong has been caused to a person, then that becomes a civil wrong. And yes, some of these civil wrongs can be termed as criminal offenses. Not all, some of these civil wrongs are be termed as criminal offenses, but not all civil wrongs can be termed as criminal offenses. So that is how it is. Coming to what a criminal, then what does criminal law include? So like I said, criminal law is basically an offense against the society, a wrong caused to the society. And it is the idea behind criminal law is to remove the vice in society, remove the badness in society. And why is that? At the end, every country, every sovereign nation aims at having a welfare state, aims at giving welfare to the people. And therefore, it is a responsibility of the state to ensure that we are living in a free and a happy and a safe environment, in a safe and a without any antisocial elements, an environment without any antisocial elements. So when these are the concepts and these are duties of the state, the government, as we say in common parlance, when these are the duties, it is a responsibility of the state to ensure that if any act it constitutes a criminal offense, then such act should, the doer of such act, the wrongdoer, the criminal, must be punished. And therefore, the state has its entire machinery, which we call as the enforcement machinery, that is the police and the various authorities, the executing authorities, who have certain duties cast upon them to ensure that any crime committed is met, any criminal who commits a crime meets the right punishment, and the punishment prescribed by law should be met with by this criminal, and he should be put behind bars. The idea behind that is that today when you commit an offense, when there's a crime is committed, it is committed against the society. And therefore, we must make sure that this antisocial element is removed. When you understand all of these concepts, and when you put these actual concepts into force, then you go to courts of law. So therefore, when we go to a court of law, there are different courts established. Not one court can, all the powers of each court are different. When it comes to civil courts, there are various civil courts, numerous civil courts. And when I say civil courts, I don't mean the civil courts having jurisdiction to your civil disputes. I mean courts which have your civil law. Civil law does not only mean courts, law under civil courts. It can include law which is like the arbitration law. That is also a civil law. You can hear matters relating to company jurisdiction, which becomes the NCLT, National Company Law Tribunal. That is also civil law. It comes with banks, that is a DRT, Debts Recovery Tribunal. That is also civil law. So therefore, all of these civil courts, that means courts dealing with, courts, tribunals dealing with civil law, have different functions. And courts dealing with criminal law have different functions, because when it comes to criminal court, they have to only look at whether an offense has been made out, whether the offense has been proven by the prosecution, and whether the accused person needs to be held to be guilty or not through the state machinery. Now, if that is the case, when both of these functions are different, there are different courts established, and therefore we lawyers choose to practice in one of these few courts. And therefore, in the beginning, I said it becomes a matter of convenience where you learn, under which senior you learn, what you get more accustomed to, what kind of matters you get, and then you choose your field, what is to be done. So as a lawyer, when you're beginning your career, making this choice in the beginning, yes, I want to be a criminal lawyer, I won't take up civil law, might not be the most practical approach, because you may never know, you might end up working with a senior who has taught you civil law better, or you might end up getting matters which are civil law related more than criminal law. So therefore, it is dependent on the functions of the courts you are practicing in, which helps you decide, and not the decision you make prior to graduation. Yes, I want to practice in this court and I will practice in this court. However, again, like I said in the beginning, we have to still understand the concept. And then when we try to understand the type of concept, we need to understand what are the type of cases which are going to be filed in a civil court and in a criminal court. As far as criminal cases are concerned, as a law student or as a young lawyer, one must remember that mainly as a criminal lawyer, you have to deal with about 3 statutes. These are the main statutes. They comprise in this thing which you call the criminal manual, which includes the code, criminal procedure code of 1973, the Indian penal code of 1860, and the Indian evidence act of 1872. These 3 statutes provide the entire law as to how a criminal offense is to be prosecuted, how it is to be gone about, what constitutes a criminal offense, how a person who has been accused of a criminal offense has certain rights, and how they need to be protected. So when we come to these 3 statutes, they are the main statutes which you as a criminal lawyer need to understand. And therefore, what the IPC does is IPC defines what offenses are. See, when you think of an offense, something may be an offense in a particular area, depending on the kind of people who live there. And the same act might not be an offense somewhere else. We can give the best example where countries where homosexuality is not an offense. The same act can be considered an offense where in countries there is where homosexuality is criminalized. By homosexuality, I mean by same-sex intercourse, which was recently decriminalized. Consensual same-sex intercourse was recently decriminalized in India. Or when you talk about where countries where smoking marijuana or usage of any certain type of narcotics is permitted and permissible under that country, whereas it is totally criminalized in certain different countries. So when you consider these type of things, so therefore the same act is an offense in one country and is not an offense in another country. So that what I mean to say by this is that an offense is only an offense when it is defined to be an offense by the state. And therefore, for us in our country, we have the Indian Penal Code, which is the complete code substantive law for defining most of the offenses in our country. Or you can say all of the offenses, because the remaining offenses which might not be defined in Indian Penal Code, they arise out of certain provisions within the Indian Penal Code. So the IPC is one statute which you must study. And when you come to ask me what type of cases are dealt with by the criminal courts, they are all the offenses under the IPC. So if any act is defined as an offense under the IPC, then that act will be considered an offense, and therefore you will have to be tried before the criminal court. Having said that, we as humans evolve, society evolves, man becomes smarter. Man by man mean a human being becomes smarter as he grows. So therefore, once a human being is caught for an offense, he might become smarter, and the kind of offenses which are being committed change, and the method of committing the offenses changes. And therefore, the law also needs to develop. So the Indian Penal Code, which existed in 1860, cannot cover the kind of offenses and kind of acts which are being committed today as well. So therefore, there are special statutes. We have things like the NDPS, the Narcotics, Drugs and Psychotropic Substances Act. We have the PMLA, Prevention of Money Laundering Act. We have the MCOCA Act. We have the changes and the amendments in the Information Technology Act. All of these have changed with the times and changed with society. And they have also defined what can be offenses and what constitute, as you can say, modern offenses, like the white collar crimes, which have suddenly become so rampant. So law, like we all know, is dynamic, it's ever changing. And therefore, when we have to study criminal law, when you deal with cases under criminal law, the type of cases under criminal law, you will have to learn these substantive statutes. That will be the IPC, the NDPS, the PMLA, the MCOCA. All of these will define what are offenses. And then when you get a case, if you're for the prosecution, you have to show how the person accused of the offense has committed an act within the definition of that certain act as of that offense. And if you're for the defense, you have to show how the acts committed as alleged against your client do not fall within the definition of that offense. And that is what constitutes a substantive law, and your job as a lawyer to study these substantive laws. Second thing which is very important is the Code of Criminal Procedure, the Criminal Procedure Code of 1973. That determines the entire procedure for a criminal case. That is the trial, pre-trial, post-trial, how a criminal court should handle and deal with a criminal case. So as a lawyer, especially as a defense lawyer, studying the CRPC is of utmost importance, because your job will be to find loopholes in the case of the prosecution, in the case of the police, in the functioning of the police, to show that they haven't complied with the CRPC. You should know the CRPC by the back of your hand, and therefore that is the second statute which you must know. Thirdly, when we talk about trial, we talk about the Indian Evidence Act. Another statute which is of utmost importance, not only for criminal, but also for civil cases. And what the Indian Evidence Act determines, the Indian Evidence Act determines the manner of proof, how to prove things. Not once the CRPC provides a procedure, they will just say how you go about these things. After step A, there's step B, there's step C. But when you begin a trial, how do you prove? Can I just produce a photocopy of a document and say, yes, this shows that the accused has committed a crime? No. Whether this document is admissible or not, whether this, suppose you have recovered an object, suppose you've recovered a murder weapon, whether this murder weapon can be taken into evidence and can be used to prove that the person has committed the murder with this weapon, that is also a question which the Indian Evidence Act helps you decide, helps the court decide whether it's admissible or not. So these three statutes, along with, like I said, the tributaries, the other modern day statutes which define law, are what a criminal lawyer must learn. So then what are the basic job, what is the job of a criminal lawyer? Primarily, according to me, there are four. I can divide the job of a criminal lawyer into four different tasks, you can say, or four different aspects. One is the pre-trial process, which a criminal lawyer must be able to deal with, the type of case he'll be dealing with. Those are your very famous bail and anticipatory bail applications, and those are something that become so common. In fact, nowadays when we counsels argue the matter in court, when we argue a bail, we argue like it's a final hearing matter, and as though it is going to be heard and decided finally. But having said that, that's not the purpose of bail. Just to give you all an example of what bail is, there's a saying by various judicial precedents, by various judgments, that bail is the rule, jail is the exception. So when we say bail is the rule and jail is the exception, meaning the rule is that everyone must be granted bail, only in certain exceptional circumstances that the person must be kept in jail, and all this is pre-conviction. This is pre-decision of the court, meaning during the trial or pre-trial, whether the custody of the accused is required or not, that is what the court decides in a bail and an ABA. And an anticipatory is pre-arrest bail. A bail is post-arrest bail, obviously, which is when you're released. It is only in cases of non-bailable offenses. All these offenses which are there in our country, they're either determined to be bailable or non-bailable. It's basically as per the severity, the graveness of the offense, that they decide whether it's a bailable or a non-bailable offense. But once it is defined to be a non-bailable offense, your job as a criminal lawyer would be to help your client, if you're a defense lawyer, to get out of jail or to get pre-arrest bail. And whether the actual custody, why do police require the custody of your client? Is because to investigate into the matter. Again, I'm talking about pre-conviction. I'm not talking about post-conviction. When I'm talking about pre-conviction or acquittal, pre-judgment, why does the police require the custody of your client? Would be to investigate into the matter, or to secure his presence, to ensure that he does not flee away, to ensure he does not tamper with the evidence, to ensure that he does not trouble the witnesses or to threaten the witnesses. Therefore, we have the provisions for bail and ABA. So as a criminal lawyer, like I said, there are four things. One of them being the pre-trial jobs. Yours is bail and ABA. Or also we have other things like discharge. When a charge sheet is filed, after investigation, the police officers file a charge sheet before the criminal court. And based upon the charge sheet filed by the police authorities, the magistrate frames charges against the accused. So as a defense lawyer, you have an opportunity pre-framing of charges to seek discharge from the offences, saying that no case is made out after investigation under the charge sheet and therefore your client deserves to be discharged. That is when we come to the first thing as a job of for the job of criminal lawyer, there is pre-trial duties. Second thing which is a job of a criminal lawyer, which is the most important and I think the most challenging aspect of a criminal lawyer is trial. Because when we do a trial, when you do a criminal trial, it is the most tasking. It was a tasking job because it is your duty to prove, if you're a defense lawyer, the innocence of your client. And if you're a criminal lawyer, if you're a prosecution lawyer, it is your to prove that the accused has committed the offense. And when we say you have to prove, is that you lead evidence or to cross-examine the witnesses and you to cross-examine them in such a way that you get the real truth out. What is a trial? When one asks, what is a trial? Trial is not some process of putting somebody in a box and questioning him and outsmarting him. Trial for the court of law is a truth-finding process, is to get out the truth, to know what has actually happened. If people who are into dramatics and theater, what a scriptwriter does is what a trial court advocate does. Because like when Shakespeare wrote Othello or when he wrote a Hamlet, he wasn't present in Denmark when Othello actually took place, or he wasn't present in before Christ's Rome when he wrote Julius Caesar to know what Julius Caesar did and to know how Brutus murdered Julius Caesar. He wasn't there, but he imagined it and he pictured it, and he pictured in such a way and he wrote it down in a script, and that script became the truth for us today. And that truth is what we know as Julius Caesar, because that is how it's enacted today. That is the job of a trial court lawyer. You have to reenact the scene as if the judge and the accused and the victim and all the police all are present in that scene over there. And then you have to enact the scene as to show whether the accused had actually committed or not committed the offense. And that is how tough the job is of a trial court lawyer. And that is how a criminal lawyer should do his trial duties, by learning the CRPC, by the Evidence Act, studying the material. And let me tell you, being a trial court advocate, you cannot only study the law. You need to know various other things. You need to know forensics. You need to understand psychology. You need to understand sociology, general logic, all of these things which we learn in our, for the people in the 5-year course, in our pre-law subjects. They are also grave importance, of vital importance, not grave importance, of vital importance, because these concepts help you understand how to conduct a trial. These subjects help you understand how to conduct a trial, how to understand the person, how to go into the mind of the person, and then how to spill out the truth from his mouth itself. And that is the job of a trial court. So that is the second job of a criminal lawyer. The third job is post-trial. Those involve appeals, revisions, when you have to challenge the judgment, the final punishment, if granted, or if the acquittal of the trial court. Before the higher court will be the sessions court, the high court. So yes, that is a post-trial work, which is also very important job, because sometimes grave errors are committed by the trial court and those need to be corrected by challenging that in appeal. The last and the fourth job is the constitutional functions of the High Court and the Supreme Court, which we choose to exercise our rights under these powers by approaching the High Court under 482 of the CRPC, read with Article 226 for enforcement of your fundamental rights. You file a writ of habeas corpus, or you file an Article 32 petition for habeas corpus. You seek mandamus. So when you file all of these petitions, you directly approach the High Court or the Supreme Court in exercise of their constitutional functions. And that is the fourth job, according to me, of a criminal lawyer, the fourth primary job of a criminal lawyer, to learn how to approach the High Court for quashing of an FIR, for other things like parole, furlough, and seeking general directions under 482 against the state machinery. So these are the four things. I'll just repeat it because it's a little longish. One was about the four main jobs of a criminal lawyer for criminal cases. One is pre-trial, that is ABA, bail, discharge. Second is actual trial, of conducting a trial. Third is post-trial, there's appeal and revision. And fourth is in exercise of the High Court's and Supreme Court's constitutional functions, you approach them under 482. When you are a criminal lawyer, though, your main job, you do all of these different things, but your main task is that you have to basically, when especially your main work will be working as a defense lawyer, because rarely do you actually get to appear for the prosecution side unless you are a court appointed prosecutor. And that also happens rarely. Not everyone gets to be a court appointed prosecutor, the state appointed prosecutor. So you generally always are appearing on behalf of the accused. And therefore, many of your friends must have asked you, at least many of my friends keep asking me, how do you appear in these criminal cases? How do you defend these criminals? So this is a question which none of us can really answer, because we aren't actually defending the criminals. That is not what we do. We are assisting the court, and we are assisting somebody accused of an offense to come to the truth. We are helping the court to come to a truth. And the person who is being defended, he also has a right for defense. He also has a right to an advocate. Just because he has committed an offense, you as a criminal lawyer have not committed any offense. Just because you have represented him does not mean that you are a criminal. So people who have this thing, how do you represent these people? How do you represent them, and how do you speak? How do you be so dishonest and try to get them out of jail? So for that, the answer only is, if any of your friends ask you, and that's the answer I give my friends, is that we aren't representing criminals. We are representing the truth, and we want the truth to come out, and that is why you do it. Yes, that does not mean that all people are innocent or accused of crimes. There are many a times when you have to represent persons who you know are guilty, and you try your best to be work as hard as possible to come to help your client get out of jail. But that does not mean that it's the most right thing to do morally. Having said that, that is a part of the criminal profession which you will have to deal with yourself and help yourself out of it if you doubt yourself. So yes, your task as a criminal lawyer will be most of the times to defend the accused and not the state and not the government, and get justice for the victim. That'll be very rare. You can't say rare, but that won't be as often as you'll have to defend the defense or the accused. And the idea would be that you will have to prove and to show the court that there is a single strain of innocence. It is not that you have to prove that he is fully innocent. You have to show the court that there's a doubt that he might be innocent. And you just have to raise a doubt in the mind of the court. Find a small loophole which can convince the judge that maybe he could be innocent, because you have to prove that a person is guilty beyond reasonable doubt. So your task as a criminal lawyer will be to prove that there is a criminal defense lawyer, that is, that there is a certain doubt in the case of the prosecution which could result in him being innocent. When I can give an example of the Salman Khan case. People are so enamored by this case. It's a celebrity case. Obviously, there's a full trial by media, and the entire society had decided that he is guilty. Now, unfortunately, that happened. That is not a very fair trial, which you can say, because there's already a trial by media, which is not permissible under our law. Not that I'm supporting Salman Khan or saying that he's innocent, but I'm just going by the books and what actually happened in the case. That when he was accused of being behind the wheel, drunk, and killing people, running his car over certain pedestrians who were sleeping on the road, people had presumed that he was guilty because it seemed like a very open and shut case. That is why people presumed it. And it seemed as though it was impossible that it was anybody else but him who was driving. But to his fortune and to the hard work of his, due credit to the hard work of his lawyers, who worked so hard to show that they raised a doubt in the mind of the judge who acquitted him, who found him not guilty, that for the offenses he was accused of, there is a doubt that he might not have committed those offenses. To elaborate more on this, Mr. Salman Khan was accused not of rash and negligent driving which caused the murder, but he was accused of actual murder. Now the standard of proof of actual murder and an rash and negligent act amounting to murder, which we say culpable homicide not amounting to murder, are completely different. How do you prove a murder and a culpable homicide not amounting to murder is completely different, and you won't have to follow the same levels of proof for both of them. So as a criminal lawyer, what his lawyers did was they showed the court that the offenses for which he was charged, that was murder, do not make out in the facts of the case. And therefore, what they did, Salman Khan's lawyer, what they did is they raised a strain of doubt in the mind of the judge that maybe he hadn't committed the offense. And just on the basis of this maybe, which was raised by the lawyers of Salman Khan in the mind of the judge, he was acquitted. So your job as a criminal lawyer is not to show how innocent your client is, but just to show the judge that maybe he's a little innocent, raise a doubt in the mind of the judge, and that will suffice the purpose of you being a criminal lawyer and make you all very famous big lawyers. When it comes to then the civil law, when we speak about what does a civil lawyer do then, let me tell you, and especially somebody who primarily practices on the civil side, that the job of a civil lawyer is not easy. You do work very hard. Not that I say that criminal lawyers don't work hard. Everyone works hard. But when you come to civil law, it becomes a very technical law. It becomes something where there are private disputes involved. Rights of private citizens, rights of private individuals are involved. And they come before an unbiased, independent court who has to make up its mind who is speaking the truth. When suppose two of your friends come and they say, listen, this person A did this to me. A did this. B says, no, I didn't do this. He did this to me. When they both say this to each other, how are you going to decide which is the truth? So for that, they both will have to come to you and tell you, listen, I did 1, 2, 3, 4 steps. Then the other was, no, I did 4, 5, 6, 7, 8 steps. So you have to scrutinize each step. Step 1 was this, step 2 was this, step 3 was this. You say step 4 was this, step 5 was this. You actually analyze, you have to analyze both of these and come to the conclusion who is actually right and who is actually wrong. So when the person is actually coming to the court and the court has just such a voluminous task of deciding between two private individuals whose private right has been infringed and to what extent, the persons coming have to come with a very specific and a hard-bound case, which cannot, like we say in the criminal case, the prosecution's case has to be spot on. Similarly, as a lawyer, as a civil lawyer, you have to work so hard, you have to be so specific, and all the technicalities or the technical objections which can be raised, the defenses that can be raised by the other side, you have to be able to counter them. So your case should be so foolproof. Unfortunately, in our country, the cases go on for years and years, 10, 15 years sometimes civil cases go on for. So imagine a case has to be so foolproof that today when I send my legal notice, not only my suit, when I send my legal notice, so foolproof that that legal notice should result in a decree 10 years later. So that is how much your hard work and how much effort you have put. Your research work has to be tremendous. You need to know so many laws. You cannot just study 3 laws like in the criminal and master them. You have to master not only the CPC and the Evidence Act, but you have to master various other laws. And you cannot not know these laws because our objection can be raised under any of these laws. Like I told you in the beginning, civil law is so vast that an objection can be raised under any of these laws, saying that this is not a dispute which can be decided by the civil court. This is not a civil dispute. No civil wrong has been committed. And therefore, the task of a civil lawyer is of a lot of hard work, a lot of technicalities, a lot of details, and a lot of efforts. A civil lawyer, if you have friends working in law firms, you'll see them who are generally on the civil and corporate side. They are working till 1 a.m., 4 a.m. 4 a.m. Sometimes they're working 24 hours, they're just working. These law firms are actually working till that late. Not in law firms, but all lawyers. When I have a very tough civil case, I'm sometimes working, burning the midnight oil almost for the whole week. And why is that the case? Is because there are a lot of intricate details which you need to go into. So as a civil lawyer, you must remember that, many people have this opinion, civil law is very boring. I don't understand. Criminal law is very charismatic. It has got so many different aspects. I'll deal with murderers. I will get justice to people. That is the general approach. But that don't have that. That is a very wrong approach. In fact, I have a lot of juniors and colleagues also who are very inclined towards criminal law. They only want to work on criminal law. But that does not mean that's going to satisfy you as a lawyer. That does not end the task. In the end, when you're working as lawyers, you owe something to the society. And the amount of charisma that is there in criminal law, the same amount of charisma is there in civil law. It's just that there is a little bit more technicalities, more reading, and little bit more efforts to be put in as compared to in a criminal case. And therefore, people get a little demoralized. My advice to all of you is don't get demoralized. The amount of fun that is there in studying the civil law, you will not find in any other type of law, be it criminal, constitutional, whatever it might be. And the kind of justice you can get to somebody in a civil dispute at the end of it is the most satisfactory. And I can tell you that with personal experience. So having said that, the job of a civil lawyer is to ensure that all the nitty-gritties and details are met with, and that the case that some wrong has been caused to you, you prove it that that wrong has been caused to you by the other side, and this private wrong caused to you needs to be dealt with and your rights will be protected, and that will be your job. Not only this, civil law includes so many other rights, so many other laws that is between landlord and tenants. So the kind of proof in a landlord-tenant dispute is different. So you learn the Maharashtra Rent Control Act in Maharashtra and the Small Causes Court Act, because the disputes of landlord-tenant, those civil in nature, they're determined by a special court as the Small Cause Court. There's family court. Family court deals with only husband and wife disputes. Completely different law, completely different sets of proof and standards, completely different sets of procedure in a family law. But again, you have to learn that, you'll be able to do that. And then there are like more corporate sectors like the companies law, where you go to the NCLT. I already mentioned that there's a DRT. When it comes to corporate societies, there's the cooperative court. When it comes to public trust, there's the charity commissioner. So various laws and authorities, tribunals, statutory tribunals, quasi-judicial authorities, courts, all of these are there under the civil law, determining the rights, private rights of an individual. And your job as a civil lawyer would be to put your fingers, dip your fingers in all these bowls and try to learn them. And it is not a very difficult task, let me assure you. I'll give you a guarantee that none of it is a difficult task. In the end, my senior always tells me, law is codified common sense. What appeases to your common sense is law. It's not that, oh, I have to study so many different laws. I have to study 100 different statutes. I cannot do civil law. I'll do criminal law. I'll only do 3 statutes. That is not the case. Law is codified common sense. If a certain provision appeases to your common sense, that same provision will be there in different words, in different codes, in different languages, for a different statute, under a different statute. But the basic fundamental on which this law is made is the same. In fact, now as a young budding lawyer, arbitration is basically a substitute to the regular courts, which forms a part of the civil law. Arbitrations cannot deal with criminal law. I can assure you that. So arbitration is such a vast developing concept. So arbitration is a type of law which you can get yourself into. And I don't mean, when I said in the beginning, don't choose between criminal and civil, I don't mean that you should not specialize. Please specialize in whichever law you like and what do you enjoy. Because in the end, once a person specializes, that is when he understands the details, and that is how he can help a client actually get justice. Because the person who specializes in these laws, they are the real true luminaries of those professions. So that is what the job of a civil lawyer is. And the different kinds of law, like I said, always depend. You can specialize in these few laws, but as a civil lawyer, what you must take up is every different type of law. Because once you choose to specialize in a certain type of law, you're going to restrain your growth and your learning curve. That is what I would always feel. Having said this, I was told today to distinguish between civil and criminal law. So I think I've covered most of these differences. But what you must understand mainly is that what criminal law is based on. Criminal law is based on the basic criminal jurisprudence, which you all must have heard from your first year of law. Let 99 guilty men go scot-free, but let not one innocent man be imprisoned or be punished. That is what on which criminal law is based. A criminal law is based that no individual's rights should be violated. No person who could be innocent can be punished. And therefore, the law is based in such a way is to protect the rights, the liberties of a citizen who could be an accused or who is an accused. Therefore, you will see the law in general in the criminal aspect. They barely talk. In fact, there's not a word of the word victim in CRPC till recently, till the amendment came recently. Victimology, or actually thinking on behalf of the victim or protecting the victim's rights, is very close to nil under the code of under criminal procedure code. What it basically defines is to protect the rights of a person who's accused of offense, so he does not go behind bars if he is actually innocent. And therefore, criminal law, the kind of task you have or the kind of work that is there, is about ensuring that no innocent man should be imprisoned. That is what criminal law is, to make sure that no innocent man is in prison. Not that you have to get everyone arrested, or not that, oh, this person must be guilty and he cannot be innocent, therefore he should be arrested. That is not what a criminal law is based on. And if you get this basic concept in your head straight, and then understanding criminal law will never be difficult, because the whole criminal law is formed on this jurisprudence that let 99 guilty men go scot-free, but let one innocent man, let not one innocent man be punished. So if you even see the CRPC, everything is based on this concept. And therefore, once you get this concept imbibed in your head, understanding these acts won't be that difficult, and understanding criminal law won't be very difficult. So as a job of a criminal lawyer, your job will be just to show that the man is innocent, like to raise a doubt, like I told you before. As far as civil law is concerned, it is something completely different. Civil law, the burden of proof is on both the parties, mainly. The person who comes to court and asserts something, the burden of proof is on him. If he fails to assert it, his case, if he fails to prove his assertion, his case is dismissed. Or similarly, if the defendant says something and he fails to prove it, then the plaintiff's case is allowed. So here, there's a balance of proof, a burden of proof on both the parties, which keeps shifting in a civil dispute. And therefore, the kind of work you need to put in is not to find some strain of doubt or let some prove that someone's innocent, but you have to be able to prove your case. So the standard of proof is much higher. In criminal, you have to just disprove the case, and therefore when a criminal court has to see that something is proved, they have to get it proven beyond reasonable doubt. But when it comes to a civil matter, you don't have to get proven beyond reasonable doubt. It is based upon what we say preponderance of probabilities. You weigh the probabilities and then you determine what is the truth and what is not, by seeing what has been proven and what has not been proven. And therefore, in fact, there are various judgments which speak about this, and there's a concept which you should also keep in mind, that to understand the difference between civil and criminal law, that a judgment of a civil court is binding on the criminal court, but the judgment of a criminal court is not binding on the civil court. And why that is? Because if you can disprove something in the civil court, then you can definitely not prove it in the criminal court. I'll give you an example. I have a case where my client has been accused of committing rape. It is my client's case that's a completely false and bogus case. And factually, it could not be a real rape case because the allegations can never be construed as rape. They aren't, and they cannot be. However, the lady, believing that she was offended in a wrong way and the crime was committed, approached the police, and an FIR was registered against my client for under section 375 for rape. Now, they both were also working under the same employment. They were working in the same company. And therefore, she approached her company as well and asked for his removal because he is a rapist, in her words. Therefore, there was a departmental inquiry for misconduct against my client, as well as a criminal prosecution. Now, In the departmental inquiry, there's a full-fledged trial, a civil trial, we might call. In this civil trial, the standard of proof was as per a civil procedure, not as per the criminal procedure, and we disproved that my client had done any misbehavior or committed any acts of rape or whatever you might call it, and therefore no inquiry can be held against him, and he needs to be continued employment. And therefore, we were able to prove that there was no such offense of rape as far as the departmental inquiry is concerned. As far as the civil case, there was no case made out for rape. This finding of the civil court became binding on the criminal court, because if the lady could not prove that she was raped in a civil dispute, where proving the standard of proof is much easier and there is a higher chances of proving it, then it is impossible to prove that rape was committed in a criminal court, because the standard of proof is much higher, and not only they have to prove that there is guilt, but they have to prove beyond reasonable doubt that there is guilt. And that is a very good way of distinguishing something that is a civil offense and a criminal offense in our country, or criminal jurisprudence and civil jurisprudence. And therefore, I told you, the judgment of a civil court is binding on a criminal court, but not vice versa. In fact, this also happens in check bouncing cases. In check bouncing cases, what happens is there's an offense under section 138 of the Negotiable Instruments Act. If your check bounces, that's a criminal offense, and you're tried before the criminal court and you're imprisoned and fine is levied. But to recover the monies, you have to actually file a civil suit. So in one of my other cases also, and general case also, when the civil suit is dismissed for the same amount, for claiming for recovery of the same amount, then the criminal case cannot stand for the 138, because if it's not a debt under the civil law, it can never be a debt under the criminal law. And that is how you basically decide it. Just to wind up, to decide between what you have to choose between a civil field, what tips do you all need to decide between a civil court and a criminal court, or deciding to go into civil field or criminal field? My best advice again would be that don't pick a field. You don't get too picky very early in your career, because I'll give you an example of myself. I am somebody who who never identified himself as a criminal lawyer or a civil lawyer. I did obviously start more on the civil side, but today I can tell you very proudly that I'm taking up not only civil cases, but criminal cases, and dealing with them very well and ably in both of the fields. So it is not that because I made that choice, that had I made that choice in the past, and I have actually colleagues who said that no, I'm a criminal lawyer, I don't take up civil work, and they actually lose out on matters and lose out on the experience and exposure to learn, because they have already made up their mind that they want to do criminal law, they don't want to do civil law. So first and foremost, my advice would be, please don't get picky. You choose what work you get. Do criminal work, do civil work, learn all kinds of law, do both 110%. And you must take up all kind of work that gets you, because finally, what are we? We're lawyers. We're doing a very noble profession. We owe a duty to the society as a lawyer. The legal profession came into force because, let me tell you, when the legal profession actually came into existence, lawyers used to not charge a single rupee. They should do it as a duty to the society to help them get justice, to show them, and because they were so knowledgeable and they're so learned, they were like the clergymen and all of those kind of people, and they used to impart their knowledge and help. They used to study the law and help the downtrodden, the innocent citizens get justice. And in return, they never asked for fees. They used to just hold a bag at the back, and when you cross the village after helping the people used to put some grains, some livestock, some sort of food in their bag, and that is how the lawyers used to earn. And therefore, just to give you all a reference, all of you who are lawyers will know, we wear a gown, and in our gown there's a small pouch at the back of our gown. That pouch actually is a resemblance, or is an anecdote to the olden style where people used to put their monies for the pouch, in the pouch. Now I don't think anyone's fees will fit in that very tiny pouch. We require big backpacks for us. But that's on a lighter note. My point over here is that a profession is a very noble profession. We owe a duty to the society, and we don't just call it a noble profession. We aren't just compared with doctors because because the amount of fees we charge, or the kind, because we are said to be arguing in court or we speak very well. No, we are said to be lawyers. We're said to be a very noble profession because we perform a duty towards our citizens, towards our people, towards the society. We help them get justice. We assist the court in coming to the truth, and therefore don't choose this or that, civil or criminal. Do whatever work, assist the society, help the society the way you can in your best possible ways. Learn, grow. You will earn money whenever you have to. That don't worry. First learn. Spend 5 to 10 years in. I am still learning. I'm only 5 years in my practice, and I don't would recommend nobody to choose one sort of field. Do all kinds of fields and try to learn as much as possible, because in the end what you're doing is more of a public duty. And in fact, that's why I feel that even in our course there's no specialization. Like in engineering, your specialization, there's EXTC, there's computer science, IT. In our course there's only one law. Everyone learns only one law. They don't expect you to learn criminal law separately, civil law separately. They expect you to learn the law and you make whatever use you want out of it. Or if you want to make a choice, then I've given you a basic understanding of what these two concepts are. You know yourself better than me 100%. You know yourself the best. So you can make the choice and you can decide what you really want to do based upon what you have heard me.
What cases are taken up in DRT courts?
So the DRT is known as the Debt Recoveries Tribunal. It is established all over the country under the RDDB Act. They deal mainly, and it is formed for the purpose of banks, for banks to recover monies. To give you a more clear idea that before, when banks had to recover monies under loans and under their transactions, they would have to file a regular suit before the court. And as we all know, suits take years and years. So it became very infeasible for banks to actually recover their monies. And therefore, the government itself formed this DRT, and they enacted this SARFAESI Act, which helps the banks recover monies without the intervention of the court. So the judges or the officers who sit in the DRT are ex-bank officials, ex-judges who are dealing with financial matters, ex-bank personalities. So therefore, they deal with only cases in respect of recovery of debts of borrowers from the bank, for the banks.
Under whom should a person start interning with an advocate or with a judge?
Okay, if you're talking internship, it all depends on what you want to really do. If you want to get into litigation, and I want to actually inform all of you guys that I am speaking very strictly in the sense of litigation. My topic was very much restricted to litigation. I did not tread into corporate law or firm culture. That is a completely different topic. So when I gave the kind of tips and advices to you, that is only with respect to criminal or civil litigation. Coming to the question where you should intern, again, like I said, it's your choice. It depends on what you want to do. If you want to get into litigation, then yes, working under a lawyer from an earlier, having a little start, end of your 4th year, start of your 5th year if you begin, not a bad time to start. Judicial internship is not, I would recommend it always. But again, the kind of work you'll get working under a judge is really good. And you rather work under a judge pre-becoming a lawyer than post-becoming a lawyer, because once you're a lawyer, it will be impossible for you to work under a judge, and no judge will really take you. So if you want to really get that exposure, you should do it. You'll get to read a lot of briefs. You'll get to do a lot of research for the judge. You'll get to make a good rapport with the judge. You will also get to deal with various kinds of matters and look at matters from the aspect of from the other end of the bar, from the judge's end of the bar. But if you are really interested in litigation and you're really interested in growing your practice, then actual practical learning, filing, drafting, even simple things like what do clerks do, like stitching or putting the right stamps, or even like doing the small nitty-gritties of litigation. Those you will learn best with a lawyer. So if you're very much inclined towards litigation, maybe do a month or 2 months of judicial internship, but I would always recommend interning under an advocate and getting that experience first.
Many of the students often confuse between civil and criminal court proceedings. How can one be better in those things?
See, the best way of learning is by diving right in. It's like you say, you won't know how to swim till you just jump in the pool. How to know differences when you work on a criminal matter, you'll know what a criminal matter is. But academically, if you need to know, you want to know what is the difference, I would recommend reading the CPC and CRPC to understand how civil courts are formed, how criminal courts are formed, because both of these procedural codes, both these codes give in detail how courts are formed and what are the jurisdictions of civil courts, what are the jurisdictions of criminal courts, where are these established. Plus, each city has different kinds of courts, each district has different kinds of courts. So there are there's a Bombay City Civil Courts Act. There is the Bombay High Court original side rules, Bombay High Court appellate side rules. They determine the jurisdictions of all of the courts. So try to study these things, but you'll need someone to guide you at the end of the day. If you're a law student or a young lawyer, I would always recommend join a senior who will help you with these things. Don't be in a hurry to be independent too quickly. Learn your things first and then you decide what you want to do.
What are the differences between counsel and solicitor?
Actually, this difference has no longer exists today. But to make you understand the concept, a solicitor is basically a person, to put in simple words, who deals with the clients directly, who does all the work for the client, which includes like drafting, conveyancing, making the pleadings, and it's an advocate who knows, who deals with the client and prepares the case. I'm talking litigation again. But when the case is filed, the person who will argue the case will be a counsel. So the people who argue in court are known as counsels. The people who do the filing and drafting are known as solicitors. Originally, there was a concept which still exists in Supreme Court that only certain people could file matters in High Court, in Bombay High Court, which no longer exists. But therefore, before only solicitors could file matters. So therefore, solicitors were given a lot of importance. It's a very lucrative profession as well. You need to do your articles under a solicitor and give a very difficult exam with very less percentage of people passing. Then you become a solicitor. It exists till date. But the whole concept, like I said, there's not much of a difference between a solicitor and a counsel anymore. Many solicitors are now counsels, many counsels are now solicitors. So people do solicitors work as well as counsel work. Without being a solicitor, you can do a solicitor's work. But to understand the concept, yes, you need to, the person who drafts and files is the solicitor, the person who argues in court is the counsel.
If someone is interested in arbitration, where can he intern? Also, what would you suggest a first-year student start prepping with or focus on the terms of arbitration?
As a first-year student, especially if you're in the 5-year course, don't even Google what arbitration is. I would enjoy your law course. If you're very much inclined and you want to know what you need to do, you can start preparing by attending certificate courses. There are various institutes, there are various universities giving certificate courses, diploma courses in arbitration law, and that will help you. But I wouldn't really recommend it because according to me, to really understand a law, you need to practice it. The kind of things we study in our college are very futile till you don't actually practice it in the courts of law. So when it comes to arbitration as a first year student, please don't worry about it. But if you really want to, you can do certificate courses and diploma courses. Just Google research. There are various websites which are providing information. If you want to get into arbitration, what you should do? Well, arbitration in India is not as developed as it is globally. So in fact, if you're into arbitration, you should actually venture out for international arbitration, especially international commercial arbitration. It is a vast field and lot of scope for you to learn. And not only in India, but like you'll be basically dealing with clients all over the world. And there's a need, since lockdown, there's actually a need for like persons dealing in international arbitration. Since COVID, not lockdown, since COVID is a need because a lot of vacancies in international firms. So if you're into arbitration and you want to know where to study, you should join a firm or a lawyer who does majorly into arbitration. There are persons who are appointed, there are a lot of counsels and retired judges can intern under retired judges also, who act as arbitrators, who are appointed arbitrators. So there you'll get to understand how arbitration is. Intern under retired judges or intern under lawyers who are doing specially arbitration or firms doing special arbitration. If you want to do arbitration in Bombay, the best place is to work on the original side in the Bombay High Court. Generally, counsel are doing a lot of arbitration work on the original side in the Bombay High Court. A lot of firms also doing arbitration work. And I would also recommend maybe doing a good course in LLM, like a good master's in arbitration law. I would recommend doing it abroad. Like I told you, in India is not much recommended. If you're not getting a scholarship abroad, then there are a few NLUs who are doing very well and giving a lot of nice arbitration courses. But yes, basically doing a master's in arbitration is recommended, and working under a retired judge or under a lawyer or a person practicing on the original side in the Bombay High Court.
How to become a counsel, and is there any exam to become a counsel?
No, there is no exam. It is you just need one gift, which is known as a gift of the gab. So you should be able to put forth your point, and like I told you, recreate the scene like you do, as if it actually took place in front of the judge. That's a job of a counsel. So there's no real exam which you have to give. It's only with experience you will learn to become a counsel. Many people claim themselves to be counsels even after 2-3 years into practice. They call themselves junior counsels. The concept under our actual practice, there's only one senior counsel who's designated by the High Court or the Supreme Court. Rest of nobody can be called a senior counsel or a counsel. But we colloquially call people counsel. Basically, counsel is someone who argues in court. And if you want to get good at it, you have to just keep learning. To be very honest, a good counsel's practice does not begin, his counsel practice does not begin for at least 10 years into his practice. So for 10 years, you forget, don't think you're going to be a counsel. Just do all kind of work that comes your way. Learn, argue in court. When you get an opportunity, argue in court. Read a lot of books, read a lot of statutes, be updated with the law. Try to argue as much as matters. Do small things like mentioning a matter or adjourning a matter. Sit in courts. That's the best learning you can get. Sit in courts. See how other counsels argue. As a junior lawyer, if you're just 1-2 years in practice, and if you're an intern, if you have nothing to do, just sit in any court. See which judge you like. See which judge you like, the way he deals with his courtroom. Sit in his courtroom and just hear. See how the seniors argue. See how they address the court. See how they strategize. And the main thing will be experience. So wait for a good 10 years, learn, argue, and you'll become a counsel in no time. Don't worry then.
Can a normal advocate argue in court without a counsel?
Yes, why not? That is the whole idea. It should be an open stage, open platform for everyone. And it is. Courts are public places and anyone can enter. They're open to the public, not public places. They're open to the public. Anyone can argue. You don't require a counsel. The reason you require a counsel is sometimes there are complicated matters, or sometimes there are some points which become very difficult for an inexperienced lawyer or a younger lawyer to convey, which a counsel can convey in a much better way and to convince the judge. So it all depends on the need of the matter, whether you require a counsel or not. As a rule, no, you don't require a counsel. Anyone can argue any matter. It does not matter how many years. Once you have the sanad, you can argue any matter. There is no restriction on that in our country. But as a practice, it all depends on what the matter demands, what the client demands, and what the situation demands, whether you require a counsel or not.
Any book recommendations for young law students or fresh lawyers?
Depends. See, you have to read. There are always, every different statute has a different good author. There's someone like an Avtar Singh and a Avtar Singh for CPC and company law, written very good. There's for DD Basu for the Constitution. There is Ratan Lal, Dheeraj Lal for IPC. So there are various authors. It depends on which law you're asking for. And I would recommend to read everything. You have to read judgments. You have to read law books. But mainly, just by reading, it is not going to help till you actually apply your mind and actually work on a case. So work on a particular case. And when you're working on that case, give in your all. Study the matter like you have to study. You only have to argue. You're the senior most counsel and you only have to argue the matter. And for that, read all the books possible. That should be your approach. Don't read aimlessly is what I mean to say.
Does law commentary help out for final year students during exams?
When it comes to what you should study, if you are only studying with the aspect of getting good marks, then wasting your time on a commentary might not be the best solution. Yes, you should refer to commentaries for particular answers which are very important and which you want to deal with, or particular subject which are going to be asked in the exam. Study for your exams as per the papers, not as per to learn law in general. If you want to learn law in general, learn in commentaries, actually apply it in a case and learn it in a case. So don't read commentaries unless it's of utmost importance or very necessary.
Please recommend books for Sanad exams.
For Sanad thing, it's an open book exam. You'll get notes or something. I cannot give you any recommendation. That you can ask. It's an open. Just carry all the bare acts. You have the portion. Just carry all the bare acts with you.
When one should change their job, 1 or 2 years after getting Sanad, when and how to decide it's time to change a particular law firm?
That's a very personal question. You cannot really decide. It's all upon you. If you have the confidence to become independent or change your job, or if you think you will get a better job, then you should change. It's all about where you're getting the best exposure and where you're getting to learn the most. If you're getting a good opportunity to learn at a particular place, then why leave it? If you don't think you're getting a good opportunity, then yes, you should leave it. Try to expand your scope and try to tread new boundaries, tread across different boundaries.
It is said that lawyer has to be exposure with socio aspect too. So have to learn sociology and apply in our legal practices.
I believe you've learned sociology in your law course. How to learn sociology is like it's a skill which you develop by interacting and by understanding the social circumstances. It is also, you have to be open-minded and you have to go out of your way to interact with people. You cannot have certain sort of pre-notions and stereotypes in your head. And if you do that, if you're open to the idea, sociology is all about society and how it changes. So I don't think there's any way of learning sociology with law.
Whether there is any environmental matter heard at Bombay High Court?
Yes, there are. You can approach the Bombay High Court under its writ jurisdiction and under the PIL jurisdiction, because right to a clean environment is held to be a fundamental right by the Supreme Court. You all must have read the MC Mehta case and so on. So to enforce these rights, fundamental rights to free, clean and green environment, or to protect their environmental rights, you can always approach the High Court under the writ jurisdiction or 226 or Supreme Court under Article 32.
How is litigation and corporate practice are different?
Corporate litigation is mainly related to litigation, meaning thereby people who is related to court work and with cases filed in court. That is what litigation is. Corporate includes, sometimes there is corporate litigation. Corporate is a more general concept which talks about all corporate bodies and how corporates deal with their law or deal with law. So corporate law includes not only corporate litigation, but also includes things like mergers and acquisitions, due diligence, project financing, arbitration, a lot of stuff. So everything is included in corporate. If you're talking about the corporate firms, they don't do much of court work. They do more of consultation, advisory, deal with clients directly, help them draft documents, and do that kind of work, and more like the solicitors kind of work. And the litigation is more with actual court work, filing and all of that stuff, arguing, etc.
Okay.